Well, welcome everyone to another CIPIL evening seminar. My name is Henning Gross-Ruß-Kahn. I'm one of the directors of the CIPIL, so the Center for Intellectual Property and Information Law at the University of Cambridge. So I have the great honor and privilege and pleasure, most of all pleasure, I suppose, of introducing and hosting today's speaker, which is Professor Herbert Zech. Herbert Zech is professor of law at the Humboldt University of Berlin, and he's also director of the Weizenbaum Center, which is more or less, I guess you could say, the German version of the Internet Institute, or one of the leading, if not the leading center in Germany, looking at network societies and various aspects of the relationship between law and technology. So Herbert has a long history in working on that. And so I'm just gonna, well, I mean, for me, knowing Herbert for many years, mainly through his publications and knowing him in person for a couple of years as well, Herbert has, I think, written the book about big data a long time ago, when probably few people were actually already at the time thinking about big data. But Herbert has more recently also done lots of other work, including on the topic which he's going to speak to us today about, which is liability for AI training data. So I'm not going to say much more. I'm just going to pass on now to you, Herbert. So feel free to share your screen. I understand you have some slides. And I understand you also, I think, now have reposted that link to a paper. Yeah, I see that, Springer
Yes.
online, where people can access perhaps that particular written version of more or less perhaps things you're going to be talking about today. I see already you're sharing the screen. That seems to be working, at least for me. So Herbert, all is yours. Over to you.
Thank you very much. Thank you very much for the kind introduction and for having me. And it is a great pleasure for me to talk to you today about one of my newer ideas, so to speak, which is liability for AI training data. Actually, I've written a paper on that topic, unfortunately, only in German. But I've written a paper on AI liability in general in English, and that's the one which we have posted in the chat function. So I come to the difference between the two in a minute. So bear with me for a while. Let me just start with a quote which is attributed to Joseph Weizenbaum. In all fairness, I could not really find a quote where he actually published it, but he is said to have said that a computer will do what you tell it to do, but that may be much different from what you had in mind. And that's basically what the core problem that we talk about when we talk about liability for AI. Because when Joseph Weizenbaum said this, he was talking about traditional computers and traditional software, and that was like half a century ago. But what he said is even more true today with the advent of artificial intelligence, of machine learning, where the problem of foreseeability, that you can predict what the computer will do, even gets more difficult and more complicated. And that's one of the core problems in the debate about whether we need new liability rules for AI. So for tonight, this is what I have brought with me. I will give you a short introduction into the problem of regulation of AI in general. So I've called this AI challenges the law. There are several challenges with AI, and I try to explain that in a minute. And then I will focus on the special aspect of the role of data when we talk about AI, because so far the fact that regulating AI also has to keep in mind the training data is a little bit underestimated, under-researched, arguably, but we are seeing that this is about to change. And that brings me to the third point, how to regulate training data. And I'll also say one or two sentences about how to regulate new technologies in general, which then brings me to the problem of liability, because and that's one of the key ideas of my presentation. Liability is a key element of any regulation for new technologies. And we have to look at existing liability rules, which will then basically be the second half of my talk, from contractual to fault-based to product to maybe even strict liability. And then to conclude, I will talk about policy options. I will discuss whether we should introduce some special liability rules regarding data. Because of course, we right now we have a huge debate ongoing, especially on the European level, whether to introduce special liability rules for AI, but not so much how we should deal with the data used for training the AI. Let me start with AI in general. How does AI challenge the law? Well, arguably, we have several important developments in information technology who challenge the law at the moment, or maybe will challenge it in the future. And the notion of AI, which is pretty vague and pretty old, by the way, is only part of the problem. Arguably, we have at least three major developments. The earliest one is robotics. Robotics meant as a direct coupling of software and hardware, which enables software to act directly on the outside world. And this already had an impact on legal debates as far back as in the 80s, when we had a very famous case, the so-called Therac 25. This was a machine used for medical radiation to treat cancer. And due to a software glitch, it caused serious harm to patients. And that is when people realized that bad software actually can do grave harm. This was, at that time, a debate among specialists. But nowadays, for several years now, we talk about AI, and what we mean is we talk about machine learning, which has become more and more feasible over the last years. Through the last decade, you could say, we have new machine learning systems. We have especially artificial neural networks, which are which were enabled by an increase in computer power and some algorithms that were already around from the 90s as components for neural networks. And that brings me to my topic, with the advent of big data, with the availability of huge amounts of data, which could be used as training data. And these three aspects together enabled machine learning properly. And that's the reason why today we discuss so much about AI, meaning machine learning, and its implications for the law. There's a third development, which so far is not in the limelight of the juridical, of the legal debate, and that's an increase in connectivity between hardware components. Of course, we have connectivity in the form of the internet, which had a huge impact on society and on the law. You all know the debate about platform regulation, etc. But with the advent of the Internet of Things, which still is in the future, or the widespread spread of this technology in the future, we will see an increase of related legal problems, like causal connections with many actors, where, for instance, just to give an example, you will have an increasing problem to find out what went wrong. As you will see in a minute, we already do have such problems with machine learning as well. So we focus on machine learning today, and arguably this is also the focus of the current legal debate on the European level. We do have a proposal for an AI Act for a regulation. I will come back to that in a minute. And we also do have, by now, a proposal for a regulation on liability for the operation of AI systems. Interesting enough, the proposal for this liability regime comes from the European Parliament, and we will see how the European Commission reacts to it. And we also find a definition of the term artificial intelligence or AI system in this proposal, which is slightly different from the definition in the AI Act proposal, which is broader. But I have brought this one with me because we talk about liability tonight. And as you can see, it's quite a lengthy definition. And it says AI system means a system that is either software-based or embedded in hardware devices, and it displays behavior simulating intelligence. So far, that's a very traditional definition of AI, by inter alia, collecting and processing data, analyzing and interpreting its environment, and by taking action with some degree of autonomy to achieve specific goals. And arguably, autonomy is the central word in this definition. And we do have a definition for autonomy as well under litera B. And it says autonomous means an AI system that operates by interpreting certain input and by using a set of predetermined instructions without being limited to such instructions, despite the system's behavior being constrained by and targeted at fulfilling the goal it was given and other relevant design choices made by its developer. This says, in essence, autonomy means that the programmer, that's the original designer, cannot foresee the whole behavior of the system because it is able to learn. That's the big new paradigm shift. We no longer have only programming, we also have training. And I would say this is arguably quite a spot-on definition. This is what challenges the law, not only liability law, also other areas of law. Why does it challenge the law? Basically, especially when we talk about liability, it brings with it new risks. We call this autonomy risks or AI risks, which are caused by the fact that the behavior of the system is not completely foreseeable. There is also another factor, and that is that even already existing risks, for instance, robots, robotic risks, etc., any risks that are that stem from operating a machine undergo a change in risk control, a shift in risk control. Why that? This is not only due to the fact of machine learning. Machine learning means that you have a shift of risk control from the programmer to a certain extent to the trainer. But more generally speaking, we also have a shift in control from the operator to the producer. Why that? Because machine learning is entwined with the idea of an increased automation, meaning the machine does things by itself without the intervention of the operator. And that in general means that the producer has a larger amount of risk control than the producers had previously for old style machines. And that's a very important point in the current debate about self-driving cars, because with the advent of self-driving, arguably the producers have an increased risk control and the operators and owners have a decreased risk control. And that basically is the last argument in my presentation at the very end. Liability should follow risk control. Last point, we have complex causation scenarios. If we have training data from many different sources, we could end up in a situation where we have a whole host of different actors, and it becomes increasingly difficult to attribute causation to one single actor. And that, of course, is also a huge challenge for liability law. You can see I've tried to show this this shift in the value change. Let me check out whether I'm able to have a pointer. Just a second. No. And you can see we have a value chain starting from the simple developer, going to the producer, going to the operator, and then in the end to the user. And as I said, if we have a shift in risk control, that may be a challenge for liability law. Of course, also a challenge for other areas of legal regulation. This brings me to my second point. What is the role of data and what is the role of data suppliers, so to speak, in this scenario? Well, if we look back some years, like 3 or 4 years from now, there was a huge debate going on about big data and how big data challenges IP law, maybe regulatory law, but it was a big issue in IP law. And the paradigm was that we do have a value chain starting with production of data, and the production of data, data can be produced by industries as well as consumers. That's why I've put this 2 figures there. Then these data which are produced in the first place are collected, maybe aggregated, then they are analyzed, and then this leads maybe to the realization of correlations and maybe in the end of causations, and this can be used to create new innovations. And the key point is that analysis at that time was still deeply related to the idea of a human analyst analyzing the data. So the idea is we have a human analyzing the data, then creating knowledge, and the knowledge can be used. Nowadays, we have a paradigm shift. Because we have machine learning, data sets can now be used as training data. And that means these data can have an influence on the behavior of the trained AI, and further on what the AI does on damages or even positive results directly, without human knowledge in between, without human intervention in the form of creating knowledge and then acting on the knowledge in between. And that's quite interesting from a liability law perspective, because this creates causality chains which are still quite long, but without a human in the loop. If we look at the underlying economy, this is still quite in the making, arguably, but the idea is that we will end up with data markets where we have, among other sets of training data being traded. We already have quite a lot of theoretic framework on data markets, from the old debate about big data and from the current debate about market design for data markets and competition law design. We have a distinction between primary and secondary markets. Primary markets means the markets where people who directly generate data, or people the data are about, deal the data or trade the data. And then we have secondary markets, which might become more important in the future. And this is also important because if we look at training data for AI, we have many different potential business models, starting with data as a main product or only as a byproduct of a data generating activity, or maybe even simulated data, which is also a potential market. And we have huge differences where, depending on the degree of curation of the data. If we have heavily curated data, annotated data, then we have, from the point of AI speaking, we have a form of supervised learning, where the knowledge of the curators, of the annotators, is indirectly fed into the trained AI. But we also probably have data sets which are less curated. And of course, then we have a lesser degree of influence from the side of the data suppliers on the final behavior of the AI system. Think about, for instance, training data for the medical sector, which is a sector where the risks are very high, but of course where the use is very high as well. And in that area, if, for instance, you generate training data sets for training systems who are able to detect skin cancer, that's a classical example. These data have to be heavily annotated, and the annotation has to be done by specialists, by medical doctors who know how to distinguish cancer positive from cancer negative tissue samples. And if you look at this example, it becomes immediately clear that the quality of the data has a huge impact on the quality of the system, and that faults in the data might lead causally to a damage when the system is applied. We have even more interesting topics in that area. We could think about standardization of training data, about labeling of training data. Last point I'd like to mention is, if you look at the information content, that's quite interesting. Training data, like other raw data in the old big data context, do contain some information, but only as potential information, not as actual information, because the information hasn't been analyzed, hasn't been transformed into knowledge so far. Nevertheless, it can be used to train AI. And that's interesting because that means that what the AI has learned is also implicit, not explicit, especially if we talk about neural networks. The AI may learn something which nobody has realized or known before, neither the data provider nor the trainer. Now I have talked enough about the technical background. I will talk briefly about the regulation in general, regulation of training data and of AI. How to regulate new technologies in general? Well, first of all, regulation means nothing else than influencing behavior, in that case, influencing technology-related behavior. And if you look at new technologies, for all of them, we have a kind of innovation cycle, which starts with the development of new technologies and goes on to the dissemination and ends with the application and results of the application of the technology. And we have different areas of law intervening at these different stages of a technology cycle. This here is the Center for IP and Information Law. So probably you're all familiar with the role of patent law and IP even in general, even copyright law, if we talk about software innovations, which has, among others, the important function of fostering innovation, of creating incentives for developing new technologies. And it also has an important function in the creation of markets for technologies, meaning it helps also the dissemination of new technologies. We have safety and security law, which directly intervenes when it comes to the application and tries to seek an appropriate risk level. And we have, last but not least, and that's the topic of this evening, we have liability law, which is also arguably about risk mitigation or about setting the right risk level, but it does so indirectly by creating the right incentives, quite similar to IP law, which also creates incentives and therefore indirectly has an influence on the development of technology. And liability has an influence, of course, on the application of technology. And this brings me to the last point. So we have a difference between direct and indirect regulation. And one of the beauty of IP law and liability law alike is that being an indirect regulation, it's very well adapted to knowledge problems, to situations where the state or the law maker has insufficient knowledge about how useful or how risky a new technology is, and where it better leaves it to the market to decide. So arguably, IP law and liability law are like the two sides of the coin and have to be thought together as a kind of full internalizations of positive as well as negative externalities. Patent law internalizes positive externalities, liability law negative externalities. And if I combine them together, this hopefully will create an innovation-friendly environment, which helps to bring about useful innovations and their application. If you talk about AI, the picture is a little bit more complicated because we have not only the technology, and of course, technology is always built on each other. But in the case of AI, we have the special role of data, meaning if you develop AI, you have to take into account the training data sets as an extra ingredient for the development of these new and hopefully useful, but maybe also risky AI systems. And that means we not only have to take into account the AI as such, the untrained AI and the trained AI, but we also have to take into account the data. And I already told you that we have on the table a proposal for a regulation of high-risk AI or AI in general, which focuses on the trained AI. But interestingly enough, and that brings me to my next slide, this is one of the first instances where also training data were taken into account. And especially in Article 10 of this proposal, we have an attempt of direct regulation of training data, prescribing a certain data quality, and with that trying to influence the risk of the trained AI in the end. So you can see here, Article 10, data and data governance, high-risk AI systems. It's only for high-risk AI systems, which make use of techniques, etc., shall be developed on the basis of training, validation, and testing data sets that meet the quality criteria referred to in paragraphs 2 to 5. And here you can see in paragraph 2, these data sets shall be subject to appropriate data governance and management practices. And paragraph 3, they shall be relevant, representative, free of errors, and complete. And then there's even more detailed rules about that. Tonight, I'm not talking about direct regulation, but about indirect regulation, about liability rules. And that brings me to the next point. Are there liability rules that could influence the behavior of data suppliers? And now I will have a look one after the other at possible existing liability rules. And only after that, I will, when we talk about public policy perspectives, I will come back to the question, what kind of function, what kind of influence on behavior liability rules do have. What I mean is, we have the distinction between negligence liability, which influences the level of care, and strict liability, which also influences the level of activity. So this brings me to my first point. And first of all, we have to mention contractual liability. In a setting where we have data suppliers who trade data on a market, we have, of course, data supply contracts or contracts for the supply of data. And we still do not have standard contracts for such a supply of data, but we already do see among academia a debate how such standard contracts could look like. And I've brought with me here an example from the ALI, ELI principles for a data economy, who differentiate between, broadly speaking, 4 standard types of data supply contracts. And in addition, they also talk about a data trustee contract, a data trust contracts, and data platforms. But here I've only mentioned the contracts for the supply of data. And we have a distinction between contracts who seek the transfer of data as a main obligation, where we have an exchange, for example, training data against consideration. But we also have contracts with a lesser degree of obligation on the side of the suppliers, starting with the simple providing of access to some existing data, or even only providing access to a data source, meaning providing access to a machine which generates data, not to some specific data, or even, last but not least, only the authorization of access, meaning we do not have an obligation to actively supply the data, but only to let it happen if the person seeking the data accesses the data on their own. This means we have, broadly speaking, a classification according to the supplier's control. And again, I have talked already about the control a supplier has over the quality, over the content of training data. And this, in the end, is also key for the question if the supplier has control over the quality of the trained AI and potential risks and benefits of the AI. This is only to very briefly mention, we do have contractual liability on the table, and it very much depends on the obligations which such contracts contain. But we still this is very much in the making and up to drafting contracts. There's another area of law which is quite interesting in this respect, and that's product liability. And the key question is, can we treat data sets as products? And I will focus now on the European directive, but of course this question is raised in any legal with any legal rule that is based on a liability for defective products. So the idea is we do have, in the first place, we need to have a product, and in the second place, it has to be defective. Why is that a problem? Well, the first problem is obvious. If we have a product, normally the definition in the directive is movable. So that means product is only tangible assets, corporeal assets. But there is already a discussion underway whether we should not extend the notion of product, for instance, to software. Come back to that in a minute. The second question is a product defective if it contains wrong information, whatever that means? It could be semantically wrong. It could be wrong in a sense that it leads to damages, like training data, that lead to damages because they result in a badly trained AI. And we have a very interesting recent judgment in that respect, and that's the CJEU Krone case or Krone case judgment. It was about an Austrian newspaper which published an advice to use horseradish for treating the skin, but they accidentally they printed the advice wrong in a way that they advised to use it for like half an hour instead of 5 minutes, or 30 minutes instead of 3 minutes. And a claimant was damaged by that fact. So it was damaged by wrong information contained in the newspaper. That's basically the question. Question was, is that a defective product? Is the newspaper a defective product? Well, you could argue the newspaper is a tangible asset, so that was not a problem. But the key question is it defective due to wrong information? And with good reason, the CJEU denied that. They said a copy of a printed newspaper that concerning paramedical matters gives inaccurate health advice relating to the use of a plant, which when followed has proved injurious to the health of a reader of that newspaper, does not constitute a defective product within the meaning of those provisions. This makes a lot of sense because the CJEU was concerned with the distinction between product and service. And the idea is that if you give wrong information, if you give wrong advice, this is a question of service and not of the product which contains the information. So information products are out. What about software? Well, software at the moment arguably is out as well, because as I told you, products only encompass movables, but there is a discussion going on whether and how to change the product liability directive. And one proposal on the table is to include software, maybe only software that is meant to be used for the control of machines, maybe any kind of software. At the moment, only embedded software, that means a machine with software control, is encompassed because the machine is corporeal. We have a current public consultation, or the consultation is already closed. There was a public consultation on civil liability, adapting liability rules to the digital age and artificial intelligence. And there was a whole set of different questions relating to this problem. We do already have a published report of the European Commission. This is the report that came along with the white book on AI by the European Commission. And there the Commission says, however, as software comes in many types and forms, answers related to the classification of software as a service or as a product may not always be straightforward. Yes. Thus, while software steering the operations of a tangible product could be considered part or component of the product, some forms of standalone software could be more difficult to classify. So this is still an open question, but arguably software is really something special, something different from other information products, because software is meant to directly control computers at least, and in the case of robots, also directly control machines. And therefore, there's a whole different risk potential than with other information products who, you may remember, I already told you this distinction, normally information products may only cause a damage with a human in the loop because they contain information. The information has to be taken into somebody's mind, and then acting on that information, the damages occur. So the interesting thing is training data is something exactly in between pure information and controlling software. You can see it here in this kind of overview. We have simple data and simple information, which has to be analyzed by humans or taken into account by humans and does not control machines directly. And we have software used for controlling computers at least, and in the case of robotics, thereby also directly controlling machines. And training data is smack in the mid, and we have to decide whether we rather want to treat it like products or not. Maybe the solution is to create a kind of special regime, which is something completely different from the traditional product liability and more along the lines of this new proposed AI liability rules. So sorry for this duplicate slide. Let me go on to fault-based and then strict liability. Of course, the baseline rule, the rule for liability all throughout Europe is fault-based liability or liability for negligence. And arguably, you have the same three major components in every jurisdiction. You need a breach of duty, and you need and this breach of duty has to lead causally to a damage. So the key factor when we ask whether a data supplier could be held liable for damages occurring by the trained AI, is duty of care. And the question is whether a data supplier breached the duty of care, whether there was a duty of care to supply good data, flawless data, and which could be breached by supplying other data. And there are many factors. Unfortunately, I'm not an expert in UK tort law, but there are many factors in constituting whether there is a duty of care or not. It's quite similar in Germany as well. Basically, it's a balancing exercise between the amount of influence, the risks, and the benefits. And therefore, it of course plays a huge role whether we have high-risk AI or only other AI. It is a difference whether you supply a data set for training medical devices, as I already showed you, or whether you supply a training set for training a simple listening device or whatever. And there may be many other factors. This is all still in the making. You can see tonight, I rather show you a kind of research program than answers I already do have. The key problem with negligence liability is legal certainty and provability as well. And we will see whether the existing negligence liability is enough, probably in the future. And that brings me to the last point, strict liability rules. As you all know, we only have pockets of strict liability. There's no general rule of strict liability. The most famous is the Rylance versus Fletcher rule. We have a liability for dangerous things. And you could ask yourself, are certain data, like data for high-risk AI, training data for high-risk AI, are they a dangerous thing? Maybe that's a little bit far-fetched. You could also talk about the ultra-hazardous activities rule. This has yet to be established, and still I think there is a problem of legal certainty. You could also, and that brings me already to the public policy options, you could also argue the other way around and say, if we want to foster, to create an incentive for sharing data and for using data, we do not want strict liability, but in the contrary, we want a limitation of liability. But I come back to that in a minute. I see I'm already at minute 40, but it'll only take a short amount of time. We do have a proposal on the table on strict liability for AI, but that is only for the operator of high-risk AI systems. There is no mention of data suppliers. And that brings me to the last point. What about policy options? Well, there are several options, and I already mentioned them. First of all, we could think about introducing strict liability rules, not only for AI operators. And I have to say that maybe a strict liability for operators is the wrong thing. We should think about a strict liability for the producers, meaning for the programmers and trainers. But we could also think about introducing a strict liability for the suppliers of data for high-risk AI. This seems maybe a bit harsh, but in certain areas, it might be, from a public policy perspective, the right thing to do, because it creates an incentive for the right level of activity, for the right level of care, and it also creates an incentive for innovating further, for innovating also data sets, for developing good data sets. On the other hand, we could think about liability limitations, at least in areas where we have insufficient provision of data sets. And then maybe as a third solution, we could also think about socializing the risks if we do want to make use of certain technologies and create insurance solutions instead of liability. There was a huge debate whether to do such a thing for the use of AI. I only mentioned it as one option. This brings me to the point, functions of liability. I will not lecture here on the law and economics of liability law. As you all know, we do have different effects for negligence and strict liability. And of course, we do have some problematic effects for all insurance solutions. We have moral risks, you name it. And this has to be taken into account and studied, examined very closely. Last point, who should be held liable? I think that's the key question. I already told you that maybe the user is definitely the wrong actor. Operators, yes, to a certain extent. Producers, to a larger extent than previously, and maybe in some situations also data providers. And that basically is the conclusion of this talk. And I'm very much looking forward to your questions. Thank you very much.